We want to start by dispelling a few myths before we actually get into the nitty-gritty of how to contest a trust amendment. And the number one thing we hear is, my mom never would have done this to me. My dad never would have done this to me. Well, I believe you to be true when I hear that. When people tell me that, I'm sure that they're being truthful. I'm sure that that's their true belief. But unfortunately, it doesn't help us much when we go to court. Because one of the legal grounds is not, what would your mother have done? Or would your mother have ever done this to you? That's not a legal ground. Now, that doesn't mean that it's entirely irrelevant. So as you're going through these different causes of action, like undue influence, you're going to see that there are opportunities for you to talk about what you think your mother would have done, what her true intent would be. So it's not entirely irrelevant, but it's also not entirely relevant. And it certainly is not going to win the day in court. So it's very important that you understand that going into your case, is that your opinion of what your parent would or wouldn't do really is a very small part of your case. And it really doesn't mean a whole lot at the outset. So you're going to have to find a lot more evidence than just that if you hope to win. The second thing we hear people say a lot is, well, I couldn't imagine a judge ruling against me. I feel like I'm so right and I know exactly how this should play out and I know the right result here. So I couldn't imagine a judge ever telling me I lose. Well, when I hear people say that, what I think in my own head is, well, you haven't been in front of very many judges then, because we have. And we've been in front of dozens upon dozens upon dozens of judges, and they all have different opinions. Why? Because they're all people. Your case is going to be heard in front of a judge because these are all bench trials and judges are people, and people have different opinions. They've lived different lives. They've had different experiences. And for that reason, you cannot expect that a judge is just automatically going to side with you. They could just as easily side against you. So don't think that you're so convincing or your position is so right that you're going to automatically win. It's not that easy. So it's easier to get that out of your head and concentrate instead on the evidence you need to gather to try and win your case. The third thing we hear from people from time to time is, well, my brother or sister is mad at me for something that happened 30 years ago or 40 years ago, or who knows how long ago. That may be true. There's a lot of family animosity in these cases. There's no doubt about that. I mean, people fight very hard in trust and contest cases because there's a lot of family history that's being played out. So it's not just about the law or the finances or the money. There's a lot of other emotional issues that are underlying the case, no doubt. However, whatever happened 30 years ago isn't going to be particularly relevant now. The judge isn't going to want to hear about it. They're not going to find, no judge is going to find it relevant. You have to focus on what was happening at the time the trust or trust amendment was signed. That's what really matters. It's that moment in time that we're looking at. In order to overturn a trust or trust amendment, we have to show that there was undue influence on the day and the time when the document was signed. Same with lack of capacity. You have to show a lack of capacity on the day and the time when the document was signed. So it's very important that you focus on that and don't get too sidetracked with things that happened decades ago that unfortunately a judge is not going to find very useful or relevant. The next thing we see a lot of times is people will say, well, the judge will see that the other side, they're bad people, and therefore the judge is not going to rule in their favor because I'm a good person. Well, I have to tell you that unfortunately, and I've talked to a lot of judges about this, and so has my partner, Stuart Albertson, and what we've learned over time is that judges are forced at times, or they feel like they're forced, to side on behalf of bad people because the law, unfortunately, is on their side. So judges want to make the right ruling under the law. They really do. And they try to do that in every case that they can. And sometimes that means giving the bad people the win because there's not enough evidence for the good people. Of course, that also assumes that the judge is going to agree with you that you're good and the other side's bad. What a lot of clients don't realize is that as much as you think that what you're saying makes sense and is the right result, the other side believes what they're doing is just as right. And that blows a lot of people's mind because they think, how could the other side think that they're right when they're so wrong? But Believe me, they do. People are very good at convincing themselves that they're doing the right thing even when it's wrong. So the other side thinks that they're right, they're acting like it's right, and there's no guarantees that the judge is going to decide that you're good and the other side's bad and make a ruling on that basis. It's just not likely to happen. The next thing we hear from people is the law is black and white, or I have a slam dunk case, or this case is a sure thing. That is so far from the truth. The minute I hear somebody say I've got a slam dunk case, or this is a sure thing, I know immediately that that person does not understand the law. They don't understand lawsuits. They don't understand how these cases tend to proceed. They literally are just fooling themselves if they think that they have a slam dunk case, because there's no such thing as a slam dunk case. It simply doesn't exist. And the reason for that is that the law is not black and white. The law is a people business. You have to convince a person, the judge. You have to work with people who are witnesses, and they might tell you one thing, but then when you depose them and they're in a deposition setting, they say something else. They may not remember evidence at all. Documents may not exist that you thought did exist, or vice versa. Something exists that you didn't realize was there. There's all sorts of twists and turns that come about in your case. So no case is black and white. No case is a slam dunk. And the sooner you realize that and get that out of your head, the better. Because once you understand that you have a challenge ahead of you, then you can work to surmount that challenge. But if you bury your head in the sand and you say, well, this is a slam dunk case, this is a sure win, then I can promise you that you're probably going to be a sure loser, because you're not facing reality. You're not facing facts. You're not facing what you actually have to do. So no slam dunk cases, just get it out of your head, but that's okay. That's why you hire lawyers after all, is to make your case better. And that gets me to my last point. A lot of times people think, well, all lawyers are the same. Well, I can promise you they're not, because again, this is a people business. People matter. And so the people who are handling your case, the way they're handling your case, the way they're working with you, all of that matters. And that's why you really need to find a lawyer or law firm that works well with your style. So some people want a more aggressive approach. Some people don't. Some people want to be communicated with consistently and constantly. Other people only want to be bothered when there's something important that they need to know about. Everybody's a little different in their style. And so you have to find a lawyer or law firm that meets that style so that you'll have a successful working relationship. But people definitely matter. The lawyer you choose and the way that they work your case is going to matter. And it'll actually affect what you ultimately get out of your case. Even if it's a settlement, it's going to affect what you ultimately get out of your case. So those are some of the biggest myths that we come across. And we just wanted to get those out of the way before we head down into the real meaty issues of the big challenge. The Big Challenge is presented by Albertson Davidson, LLP. We're ready to handle any big challenge. Albertson Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for hundreds of legal articles and videos to answer all your California trust questions. We'll see you on the next episode of The Big Challenge.